He is the doyen of the bar, the legal legend, the Bhishma Pitama of the legal community. We have the distinct honor and privilege of having such a towering figure in the world of law and jurisprudence among us, a luminary whose name is synonymous with excellence and integrity in the legal field. Ladies and gentlemen, Mr. Fali Nariman is a legal titan whose illustrious career spans decades and whose contributions have left an indelible mark on the landscape of Indian law. His journey through the corridors of justice is a testament to his unwavering commitment to upholding the principles of justice, fairness, and the rule of law. As we invite Mr. Nariman for his keynote address today, we're not only welcoming a legal luminary, but also a role model and an inspiration for generations of legal practitioners and aspiring advocates. His legacy serves as a beacon of hope for those who believe in the transformative power of the law to shape a more just and equitable society. Ladies and gentlemen, we give to you Mr. Fali Sam Nariman to deliver the keynote address.
Thank you. Honorable Minister of Law and Justice, it's very good to have met you and seen you and heard you. Former Chief Justice Deepak Mishra, my friend Guru Murthy, whom I am delighted to see after so many years, but fortunately we have met each other and had a bit of gups-up whilst the speakers were on the floor. And my friend Mr. Goswami, who just delivered a very strident expose. Why not a debate? He's quite right. Of course you have a debate. Nobody must suppress any debate on any subject. And this subject is actually well worded as well. I know I'm listed to speak only on a set topic, but let me tell you frankly that I have stirred out of my home this evening principally to participate in an event. The event being the centenary celebration of not only a great advocate, but also a great maverick who was also my friend. And this is why I first crave your indulgence to pay my tribute to his memory. It was said of a famous US attorney that he was such a superb advocate that he made money on the side by selling tape recordings of his final arguments in court. Jethmalani was, by common acclaim, a superb advocate. It was a treat to see and to hear him, and those of you who didn't, is a great misfortune, even though he never sold tape recordings of his arguments in court. Pushing 97, with his unstoppable, record-breaking 70-odd years at the bar, Ram sadly left us on the 8th September 2019 after setting up, and this is very important, a high benchmark of professional excellence about which you heard the Chief Justice expound in a very brilliant memorial address. In life, one has to be fortunate in one's given name. If your name has 4 letters, like Nani, N-A-N-I, for instance, it carries you a long way, as it carried the great Nani Palkhiwala in his fascinating journey through life and the law. But if your first name is only a 3-letter word, like Ram, it may carry you even further, simply because Ram is on the lips of every God-fearing Indian morning, noon, and night. It is great that his son has remembered to celebrate his 100th birth anniversary. But I have a small grievance, and I must ventilate it here. Mahesh's illustrious father, if he was with us, would have celebrated this occasion with far more aplomb, with far more panache. In the first place, he would not have planned a lecture in this hall at all. Instead, ladies and gentlemen, if I know him, and those of us who knew him, he would have hosted a party in far more salubrious surroundings, inviting you all, and served spiked beverages to all present. But alas, it's not to be. So now permit me to say a few words on the subject chosen for this memorial lecture. The basic structure doctrine is inextricably linked to what has been mentioned in one article of the Constitution, the Amendment Article 368, the only article dealing with substantive amendments to the Constitution. The constraints on constitutional amendment have been and are attempts by courts, not just in India, but around other parts of the world as well, to ensure the survival of democratic institutions and, to use the phrase of Mahesh, extremely well put, serve the nation well. Very important. Serve the nation well. In India, in the past 50 years, 1973 to 2023, the application of the doctrine has followed this particular pattern. First, the doctrine of basic structure is now established and accepted by 6 nation-states around the world: Bangladesh, Pakistan, Uganda, Israel, Malaysia, and a small country called Belize in Central America. Second, let me give you how matters stand in India between 1973, when the doctrine was first propounded, and 2023. Since 1950, we have had 105 constitutional amendment acts under Article 368, which 60 new articles were inserted in the Constitution. 17 originally enacted articles have been removed, and 154 originally enacted articles have been substituted or amended. This is not my cleverness which brings this out, not at all. It is derived from a complete list of amendments which you will find in Wikipedia. You just download Wikipedia and you will get the amendments, and you just have to look through it. Third and most important, the basic structure doctrine has been invoked so far sparingly by India's Supreme Court. As you will appreciate from the following figures, between 1973, the decision in Keshavananda, and the current year, 2023, there have been 22 reported cases in which constitutional amendments have been challenged on the basic structure doctrine, out of which, in 7 reported cases, 7 in 50 years, the challenged provisions have been struck down by the Supreme Court of India by invoking the basic structure doctrine. So it is impossible to generalize. You can certainly look at any particular case and criticize it, and there a debate would be meaningful. In 15 reported cases, the challenge on the basic structure doctrine has been repelled and rejected. That is to say, the validity of the challenged constitutional amendments have been upheld by the court. Now let's go further. The striking down has always been on some principle related to what I call good judicial governance. Not interfering judicial governance, but good judicial governance. In constitutional law, especially in constitutions that prevail in all the 56 Commonwealth countries around the world, governance is by three organs of the state: the legislature, here parliament, in elsewhere parliament, called differently, in Knesset in Israel, etc., the executive and the judicial. And in matters of judicial governance, you must know that there exists a theory about its legitimacy, expounded by a renowned academic jurist of the 20th century, a man called Ronald Dworkin. He's quite famous around the world. Dworkin had said, and I mentioned this, present-day judges who may have had nothing to do with the written constitution when it was first framed, by reason of their position as judges, have become and must act like partners with the framers of the Constitution in an ongoing project, since it is and always will be an ongoing project, to interpret a historic document in the best possible light. And he went on to say, and these are his words and not mine, judges may therefore sometimes make new law either covertly or explicitly, but when they do so, they should act as, and this is very important, when they do so, they should act as deputy to the appropriate legislature enacting the law that they suppose the legislature would enact if seized of the problem. This has since become known around the world, and you must also know this, as the Hercules technique of constitutional adjudication. Does the Herculean technique of constitutional adjudication apply in India? It does, because it is incorporated in an originally enacted Article 142 of the Constitution, an article which provides that in the exercise of its jurisdiction, the Supreme Court of India, and the Supreme Court alone, not the High Court, not the other courts, not the District Court, the Supreme Court of India may pass, and I quote from Article 142, may pass such decree or order in a case as is necessary for doing complete justice in any cause or matter pending before it. And the word complete justice in Article 142 is deliberately left undefined. It is something which, in the opinion of the Supreme Court and the Supreme Court alone, will, in the words of Mahesh Jethmalani, serve the nation well. This is important once again. Hence, for instance, and this you must remember this instance, when members of India's parliament during the period of the internal emergency, which was June 1975 to March 1977, those who were not in jail under preventive detention could not attend this session, and there were many. When members of India's parliament during this emergency had added clauses 4 and 5 to Article 368 by the Constitution 42nd Amendment Act 1976, clauses that completely precluded the court from calling in question any constitutional amendment on any ground whatever, with an added clause declaring that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation or repeal the provisions of Article 368. And when this amendment was challenged, the then members of the Supreme Court, in rare unanimity, struck down clauses 4 and 5 of 368 because of its excessively overbroad formulation. The court holding that in excluding all judicial review over any constitutional amendment, there was a violation of the basic structure doctrine. Individual members of the public may from time to time get worried, I sometimes am, with orders and decisions given by individual judges of the Supreme Court. But please, never lose faith in the higher judiciary as an institution, as one of the three constitutional organs of good governance. As you all know, the basic structure doctrine got established initially in 1973 in Keshavananda with a very narrow majority of judges in favor, 7 judges in a bench of 13. It was held by the majority, 7-6, that the basic features of a written constitution could not be taken away by an amendment of the constitution. But you also need to know something more, that in November 1975, a bench of 13 judges was once again reconstituted by Chief Justice Ray to reconsider the correctness of the majority view expressed in Keshavananda. And in this bench of 13 judges, there were 8 new judges, all appointed after Keshavananda, replacing those who had retired at age 65, which is the constitutional age of retirement. And this new bench of 13 judges heard arguments on 2 days of November 10th and November 11th, 1975. And on the morning of the third day, 12th of November 1975, when the court of 13 judges reassembled at 11 a.m., Chief Justice Ray, presiding over the 13-judge bench, suddenly and peremptorily announced, "This bench stands dissolved." And all the judges rose and went back to their chambers. And this was only because Chief Justice Ray was satisfied that the doctrine of basic structure was not to be reconsidered by any of his 12 colleagues. And this has been recorded in a constitutional law book which is now famous, Mr. Sirvai's Constitutional Law of India, where he expressly mentions this. And please remember that he was not interested, he was not a person who had any bias. On the contrary, he was the person who had appeared for government in Keshavananda, and as making the principal argument even before the Attorney General, Mr. Nirande. This is not all. In the year 2007, the basic structure doctrine was once again questioned, and yet again a bench, this time of 9 justices, unanimously affirmed the doctrine of basic structure. But lastly, and most significantly, the basic structure doctrine, or what is known as the essential features doctrine, which is its other name, has now acquired a place of permanence in constitutional adjudication, simply because, and you'd be surprised to know this, it was initiated by India's parliament itself. This is how it was done. There is an article in the Constitution, 359, which had been enacted in 1950. And it states that if during any period when a proclamation of emergency is in operation because of internal emergency or external emergency, the President of India, which in effect means the central government, is specifically empowered by order to suspend the right to move any court for the enforcement of all or any of the rights conferred by Part 3 of the Constitution, that is, all or any fundamental rights, even though in ordinary times the enforcement of all or any fundamental right is guaranteed by Article 32 of the Constitution. So also, during the period of an emergency, all proceedings in court for enforcement of fundamental rights according to Article 369 as enacted, are to remain totally suspended for the period during which the proclamation of emergency is in force. But after the lifting of the oppressive internal emergency imposed on 25th June 1975, and after the 6th general election of March 77, India's newly constituted parliament met and expressly declared by Section 40 of the Constitution Amendment Act 1978 that the right to move any court for the enforcement of rights conferred by Articles 20 and 21 even during the period of an emergency can never be suspended. To paraphrase this in legal language, it was the considered view of India's parliament, not the view of India's higher judiciary, but of India's parliament, that the fundamental right to life and liberty in Articles 20 and 21 were a part of the basic structure of the Constitution. Because in the statement of objects and reasons for this amendment, it had been expressly stated by the then government in office that this was done in order, and I quote, to check the misuse by the executive of the emergency provision. In other words, the right to life and liberty from then onwards had, according to Parliament itself, been a part of the basic structure of the Constitution. I would like to end this intervention of mine with a wish. I wish that the basic structure doctrine continues so long as people, particularly ordinary people, choose to remember that great human rights advocate of his time, Ram Jethmalani. Thank you very much.